Assalamualaikum warahmatullahi wabarakatuh, ladies and gentlemen. We are thrilled to welcome you to today's presentation by AEGIS Associates from TLB6, where we will be addressing question number 5. Next, our group consists 4 members, and my name is Nur Adilah Izzati binti Ahmad Nazri, and I am joined by my esteemed colleagues Muhammad Yakin bin Muhammad Mahathir, Nur Rafhanah Edlina binti Arshad, and Nur Batrisha binti Muhammad Rasdin, as we delve into this question together. In this question, there are two parties were involved. First one is Didi, the proprietor of the barber shop. And the second one is Lan, a customer at Didi's barbershop. Next is the facts of the case. In the scenario, one day when Lan went to Didi's barbershop for a haircut, he didn't expect what would happen next. As Didi, the busy shop owner, tossed a cigarette without looking and it landed on Lan's head and it causing trouble. Lan's hair cream was something that could easily catch fire, which is it was inflammable, and the people who made it knew that. The lead cigarette triggered the hair cream, leading to Lan's hair catching fire, which ended up causing him severe burns and injuries, leaving him in a lot of pain and distress. The cause of action in this case is trespass on person which falls on battery. We will begin with question number 5. Lan goes to Didi's barber shop. Consider Lan's liability in trespass if the following incidents happen. A. Without looking, Didi throws away a lighted cigarette. It falls on Lan's head. The hair cream used by Lan is inflammable, thought it is known to the makers. As a result, Lan's hair catches fire and he is severely burned. Would it make any difference if Lan is being sued in trespass or negligence? So for the answer, the issue is whether Didi's act of throwing away the lighted cigarette on Lan's hair falls under negligence or trespass. In this situation, they are both elements of negligence and trespass, but which one is more accurate? Let's analyze how the liability might differ if Lan is being sued in trespass or negligence. We will begin with the trespass first. There are three elements of trespass. Firstly, intention. Secondly, contact. And the last one is lack of consent. The first element of trespass is intention. Lan did not intentionally throw the lighted cigarette, so this element may not be met. The next element is contact. Didi threw the cigarette without looking, and it fell on Lan's head, causing physical contact with his person. The last element of trespass is lack of consent. Lan did not consent to having a lighted cigarette thrown at him, so this element is likely satisfied. He also did not consent to having the inflammable hair cream on his hair.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Yakin bin Muhammad Mahathir. and my metric number is 1222138. So, I'm going to continue Adilah argument about negligence versus trespass. Since Didi did not intentionally throw the cigarette, it may not be a clear case of trespass to a person. Trespass typically involves intentional actions. In Letang and Cooper, it was held that in the thought of trespass, there must be intention at the time the defendant does his act. If the defendant was careless in acting as he did, the cause of action would lie in negligence and not in trespass. However, in this situation, Didi did not have any intention to cause any harm to Lan, so he cannot sue Didi under trespass to person. Moving on to the negligence, Didi may also be liable for. In conclusion, Didi's act of throwing the cigarettes on Lan's head falls under negligence. Lee can sue him.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Batrisha binti Muhammad Rastin and my metric number is 1222136. For question number 5, B, suppose that in the above problem, Lan was sitting behind a bush and his presence was unknown to Didi and could not be foreseen. Is Didi liable to Lan? In this case, the issue is whether Didi is liable to the injury suffered by Lan. The intentional requirement in proving the case of battery is that there must be three elements of battery. The first element is physical contact with the plaintiff. There must be a direct act by the defendant towards the plaintiff, including instruments that can be used to effect physical contact. Lan must prove that the physical contact between him and Didi must have been caused by a direct act of Didi. In the case of Scott and Shepherd, the defendant threw a light squib into a public market area. A grabbed it and threw it to B, who grabbed it and threw it aside. When the squib struck the plaintiff, it exploded into flames. Trespass liability applied to the defendant. The initial thrower meant to throw the squib even if his gesture did not directly affect the plaintiff. Although the general rule is that the intention is related to the direct act of the defendant, but it is confined perhaps to cases where the defendant acted recklessly. The second element is intentional physical contact with the plaintiff, in which the act was under the defendant's control. The defendant's act must be done voluntarily. The Gibbons and Pepper case might be used to discuss this aspect of the case. When the defendant was riding the horse bolted after being struck from behind. The plaintiff was hit by the horse, and the defendant was held not guilty by the court in the lawsuit since the horse bolt and subsequent collision with the plaintiff were not beyond his control. In the case of Collins and Wilcock, a police officer held a woman with the intention of temporarily detaining her. The contact was hostile as the police officer did not have the authority to detain her. The third element is unjustified physical contact, in which there is no consent or unlawful act given by the plaintiff. This element requires that one cannot touch another person without his consent or without lawful justification. This element can be referred to in the case of Tiong Pik Hyong and Wong Se-gyu. The defendant was found liable in battery for scratching the plaintiff's face and hitting her due to her jealousy of the plaintiff's friendship with her husband. Applying the case to the present case, the first element in this situation is established when Didi throws away a lighted cigarette and falls on Lan's head, causing Lan's head to be severely burned, although Didi neither desired nor foresee Lan was sitting behind a bush. Thus, the first element is fulfilled. The second element in the present case differs from Gibbon's case because Didi did the act voluntarily. Applying the case of Collins and Wilcock to the present case, Didi himself intends to commit the act of throwing the lighted cigarette and it falls on Lan's hair. As such, this element is also fulfilled. To apply the case of Tiong Pik Hiong and Wong Se Kyu in the third element to the present case is when the plaintiff is unaware of the defendant's act, which means that he did not consent to the act of throwing the lighted cigarette that caused his hair to catch fire. In conclusion, Didi is liable to Lan. Lan has a high chance of success in the battery since all elements have been proven.
Assalamualaikum warahmatullahi wabarakatuh. My name is. For the first element, which is direct physical contact, the defendant itself must have caused physical contact to the plaintiff, which can also include objects or instruments. It is not necessarily to prove the physical hurt suffered by the plaintiff, but as long as there is a touching of another person's body or clothing, battery is automatically established. For the second element, which is intentional physical contact, the act of the defendant must be voluntarily, or in other words, it is performed by the defendant with consciousness. Even though the crime committed against the plaintiff is not intentional, if the act itself is done intentionally, it is sufficient to prove that battery had been established. To prove whether there is an intention of the defendant, a reasonable man test is applied. For unjustified physical contact, the act of the defendant is done without the consent of the plaintiff. If the act then comes together with the consent from the plaintiff, then it will not be considered as battery. Relating to the situation discussed, all the elements stated above are fulfilled. For the first element, direct physical contact happened when Didi threw the lighted cigarette and fell onto Lan's hair, which causes a serious burn on his hair. When mentioned about direct physical contact, it is not the effect of the act that will be considered, but the act itself. Which means, suppose that the injury does not happen, the act of throwing the cigarette still be considered as battery. Having said that the plaintiff actually suffered the injury, the defendant then is automatically liable for the damage. For the second element, the defendant intentionally throws the lighted cigarette casually, without considering the consequences that might have happened, which in this situation resulting the hair of the plaintiff to be caught on fire. Even though it is not intentional of the defendant to commit the crime against the plaintiff, the act of throwing the cigarette is. For the last element, Lan did not give consent for Didi to use the inflammable hair cream on his hair. Therefore, Didi's argument in this incident does not succeed. Lan alone is not responsible for the injury. Instead, Didi is liable for the injury under battery. In conclusion, for question 5A, it falls under